Hi, this is Lee Phillips again. Like I say, I'm an attorney. I want to talk to you 2 seconds about a serious mistake that people make when they think about estate planning. The mistake is going to be, well, duh. The problem is, the majority of Americans never do anything. That's a mistake. Oh, no. They think they're doing something. But the majority of Americans don't have a will. Only a tiny percent of them have a trust. And ends up they die intestate. And that does not mean they died in the neighboring state. That means they die without a will. You don't want to put your family through that, because if you don't write the will, if you don't do the living trust, the fact of the matter is you get whatever the state has for you, and trust me, you're going to love your state's will. And every state has one. I don't care which state you're in. You're going to love their will. People, they think, well, okay, I'm going to take care of it. And the way they take care of it primarily is with something called joint tenancy with rights of survivorship. That means instantly upon the death of one guy, the other guy owns it. You avoid probate. You avoid all of the problems. Yeah, that's true. First of all, though, it only avoids probate for a while. And you say, well, okay, it's going to avoid probate. Husband, wife, we put our name on, it avoids probate. Then when one spouse dies, we bring the kids in and we put them their names on the deed or on the bank account or whatever it is. It's a disaster. You never put your kids' names on anything. A kid's like yogurt. You never know when they're going to go bad. Let me talk about the disasters with joint tenancy, because everybody uses it. And I'll let you use it between husband and wife, but nobody else. Because as soon as you put the kid's name on the deed to the house, do you understand you have just made a gift to the kid? Let's say it's a $100,000 house. You're single, you bring your son in, put his name on the deed. You just gave him $50,000. You didn't file a gift tax return. That's a violation of the IRS laws. And the problem with a gift is the kid, when you die, he doesn't get a step up in basis. Let me explain that for 2 seconds. If you die and the property goes to your family, your son, your daughter, the kids, all of them, because of your death, then technically it's taxed in your estate. Now, most people don't pay an estate tax, but technically it's taxed. And so it gets a step up in basis. You paid $20,000 for the house is now worth $200,000. So if it gets the step up in basis to $200,000, the family sells the house the day after you die, they pay 0 income taxes. If, however, you brought the son in, put his name on the house, that's a gift. Son has to take the original basis on his half, at least. So he's going to have, it's a $200,000 house, he's going to have roughly let's see, now there's half of it, so we had 20,000 original basis, so we're down to 80, so he's going to pay income tax on $80,000 when he sells the house after you die. If he had gotten an even intestate without the will, it probably would have been cheaper than having him pay the capital gains tax or the income tax on the $80,000 in the house. Actually, it's not 80, it's 90, because you understand what I'm saying, whatever the numbers are. So you lose the step up in basis. Additionally, you lose control, because as soon as you put somebody's name on the deed, the stock certificate, the bank account, whatever it is, that's their property too. If you're going to sell a house, you've got to have their signature. I had a spinster aunt, and she brought her niece in and put the niece's name on everything. And the niece helped her, paid her bills. I mean, it was a great arrangement. The problem is, she went into the rest home. And in order to pay all of her stuff, the niece had to sign the checks. Well, if the niece doesn't sign the checks, The niece inherits all the property, not actually inherits, but gets it because of the joint tenancy, so the niece doesn't want to go through all that. So the niece isn't going to sign. No, actually the niece will sign. The problem in this case is the aunt. She doesn't know who she is. She can't sign. So you have to go through the whole process of naming guardian. I mean, it's a legal mess. Additionally, as soon as you put the kid's name on the house, that asset is now exposed to the son or the daughter's liabilities. Case here in town I handled. Mom and dad don't want to avoid, or they don't want to go through probate, so they bring the oldest son in, they put his name on the deed. Then the oldest son went out and he was a contractor. Times weren't too good. Contractors went bankrupt. The son went bankrupt. They took mom and dad's house because the son's name is on the deed to mom and dad's house. So you keep your kids' names off of stuff. Do you understand? In fact, joint tenancy makes it so that the property doesn't go the way you think it's going to go when you die. Mom and dad, they want to avoid probate, bring the oldest son in, put his name on the deed. 40-acre orchard. Mom and dad die. The will says this 40-acre orchard is to be divided 4 ways. So the kids go into the lawyer, same lawyer who'd actually written the will. In this case, they had a will, but they put the son's name on the deed because the will doesn't avoid probate. They wanted to avoid probate. Put the son's name on, sit down at the lawyer's office. Well, mom and dad's will says we got to divide it up 4 ways. How do we do that? The lawyer looked at him and said, son, say again, son, you own this piece of property. And wake up and smell the coffee, kid. This isn't a 40-acre orchard anymore. This is the local shopping mall. So we now have a multimillionaire son in town and 3 other kids. Property didn't go the way mom and dad wanted it to go at all. It was a disaster. People do lots of things to pass property. They make out the deed to the property, and then they put the deed in the dresser drawer and tell the kids, when we die, you come get the deed. Well, there are certain elements to a deed. Dated, property description, signature, all this stuff. One of the elements is delivery. And the courts have routinely said that the dresser drawer deed, no delivery. It's an invalid deed. So don't try these tricks. Let's just do a will. Let's do a living revocable trust. Let's get you the estate planning and do it right. You're going to save a ton of money for the family, and you're going to make life a whole lot easier for them. In my book, I go through step by step how you do all of these things. I explain the joint tenancy in detail. I explain dresser drawer deeds. And there are half a dozen other ways that people basically mess up the estate planning because they try and do it themselves and forget about the will, forget about the living revocable trust. This is a mistake that people make. They don't do anything, or they try and bootstrap it together themselves. In the book, like I say, I go through it. It's easy. I tell the little stories. You'll be able to understand it, no problem. The reason people don't do estate planning is because they're afraid. You may have the condition that you want mom and dad to do the estate planning, but if you talk to them, it's that greedy little kid. He wants my money. Just let them read the book. And that's a third party telling them what needs to be done. It's easy. In fact, it's a fun read. It's been a Time Warner Book of the Month Club book.